Hi, I'm Deb Falzoy. I'm the head of End Workplace Abuse. And today we're talking about how to testify in support of the Workplace Psychological Safety Act. So, for today's agenda, we're going to talk about a brief historical overview of the Workplace Psychological Safety Act legislation. We're going to talk about where it stands today, where it's going, expanding and building momentum together, and the ins and outs of testifying. So, here's the issue that we're addressing, which is workplace bullying and mobbing in the American workplace. And our solution is the Workplace Psychological Safety Act, which you can read more about at workplacepsychologicalsafetyact.org. And our platform is that psychological safety is a fundamental right which is being exploited in our workplaces. So, we originated as this small group of people joining forces to create change around workplace bullying and mobbing. And our group has had past experience with elected legislative officials in approaching them individually and collectively and collaboratively to tell our stories together. And this grassroots organization is called End Workplace Abuse. This is the umbrella organization that the Workplace Psychological Safety Act sits under. And this organization is comprised of hundreds of everyday people like you and me from all walks of life, all 50 states, many other countries whose lives have been disrupted by workplace abuse. And our Workplace Psychological Safety Act efforts in the US emanate from this group called End Workplace Abuse. And our scope with End Workplace Abuse is really around more workers' rights bills and trying to push them. We're also trying to push a ban on at-will employment, which if we worked under employment contracts instead, we would have a much better ability to speak up about things. We'd have a baseline of rights as workers. So we would love it if you could lend your time to us with marketing, fundraising, or organizing. We would love it if you had experience in any of those. But even if you don't, we just need people who are willing to roll up their sleeves and help us out. Our strength is really in number. And so we're trying to build a national movement around ending workplace abuse. Part of building that strength in number and leaning on our solidarity is action alerts. And in order to sign up for action alerts, you can go to endworkplaceabuse.com and sign up there or take any of the actions on the website. But action alerts will be mostly revolved around public hearings, so we can testify together, whether that's orally or written. And we'll also prompt you to lobby powerful committees together. So we'll provide explicit, easy instructions on what to do and when. Again, this is at endworkplaceabuse.com, and this group is about using our collective power to fight for workers' rights, leaning heavily on ending psychological abuse at work and also banning at-will employment. So here's what the US landscape looks like. We have teams forming or will be forming on the ground. We're trying to find a state legislator or a lead sponsor to introduce the Workplace Psychological Safety Act in their states. And we will also separately be approaching legislators in progressive states. But it only takes one legislator to get the ball rolling, and it only takes one person to prompt or to find one legislator to get the ball rolling. So we actually have already action happening in Louisiana, Massachusetts, Oregon, Rhode Island, and Texas. A couple more states adding in there, but we have a pretty strong foundation going. So if your state doesn't already have a team going and you're interested in forming one, we would love for you to join us. We'll walk you through every step of the way. You can email us at info@endworkplaceabuse.com, and there's even a toolkit with all sorts of resources, letter templates, very well organized for you. But knowing that all it takes is one person. With some states, we've been lucky enough to have a couple of people come out and want to take action, and in some states it's just one person, and that person and their action can prompt other people to take action. And especially when we have that bill number from that one legislator who's willing to introduce it, it will tell people we're serious about this. we're taking action and they'll want to join in with us. So, our whole goal is to build an army across this country, and movements are the only tool that has created meaningful change to law in the United States. So, we need you. We're forming this army of doers who not only say that we want change, but are willing to roll up their sleeves and make it happen. And at the heart of this action is lobbying and testifying. So I'm going to show you a brief video. We have Jennifer Lawrence here, who's active with a group called Represent Us. It is all about unrigging the system, especially on the federal level. But she's gonna talk about why passing state laws leads to federal victory, and this is the reason why we are taking a state by state approach. So the U.S. territory of Puerto Rico has actually already passed um, workplace anti-abuse legislation with teeth, and it is the only U.S. state or territory, in this case, a territory with a bill or with a law at this point with any teeth whatsoever. There are plenty of countries, especially in Europe, that have bills against workplace abuse, but the United States is not one of them. In fact, we are one of the last industrialized countries to do anything about this. So I'm going to play this segment for you.
This line is from a Bloomberg News study. It finds that throughout American history, passing state laws leads to federal victory. Let me show you what I mean. This chart shows the number of states over time that pass laws giving women the right to vote. When it hits the right side of the chart, that's the federal victory. Okay, now I want you to watch the blue line. We're going to do this again with interracial marriage. There were a few states in the Northeast that made it legal decades ago, centuries go by, and we hit this blue line where all of a sudden there's a rush of activity, which leads pretty quickly to federal passage. So here we are again with same-sex marriage. One state, Massachusetts, for many years. A couple decades later, we hit that blue line, a jump in state activity and federal passage. This isn't about these issues. This is about a winning political strategy. The crucial finding in the Bloomberg study is that a key event, often a court decision or a grassroots campaign reaching maturity, triggers a rush of state activity that ultimately leads to a change in federal law.
So that's why we're taking a state by state approach on this. So you might not have a state team yet, but there's no worries here. This is a national effort. You can testify and lobby in other states. There's no getting arrested for crossing state lines. We will send action alerts out to you to tell you what to do, how to do it, and when to do it. But the secret sauce here is acting together, acting in tandem. So the first part of this, like I've mentioned before, is finding a legislator to introduce the bill. So before a piece of legislation becomes law, it's called a bill. And the legislators who introduce that bill are called the lead sponsors. There's usually one or two of them, a state senator or a state rep or assembly person, as you might call it. One person on the Senate side, one person on the House side. It could be either or. We recommend trying to find a state senator first because they have more power, they have more leverage. But that bill will be assigned a bill number for that legislative session, and that also varies state to state. But about half the states have a 1-year legislative session and half have 2 years. All of the ones that have 2 years, with the exception of New Jersey, start on the odd year. So when we talk about the legislative sessions and the bill numbers, you get a new bill number every single legislative session, but you build on the momentum from past sessions in terms of the support that you've built, the number of legislators who support. You'll have to ask them again, but it builds from session to session. So here's a little overview of lobbying and testifying. So lobbying involves convincing state legislators to co-sponsor the bill or to support it in some way. It could also be opposing a bill in some way, but for our purposes, it's to support it. And constituents are residents who live in that legislator's district. So we ask our own state legislators to support the bill in certain ways. And this is an ongoing process until we get their support in the way that we want it. And I'll get to that in a second. But testifying is a bit different. It's talking at a public hearing. It doesn't necessarily have to be oral. It could be written. It could be submitting written testimony. But these public hearings take place each session that the bill is introduced, and anyone can give testimony in support or opposition. Like I said, orally or written. It can be advocates. It can be citizens of that state. It can be people outside of the state. It can be organizational representatives. It can be employment lawyers, therapists, psychologists, professors, anyone who has some sort of angle to bring to this issue. And the committee members, it's usually a labor committee, who listen to the public hearing testimony, decide whether or not to move the legislation forward. If they don't, the bill dies in committee and will need to be reintroduced the following legislative session. Now, keep in mind, this whole process takes years to move, to end up with a law. In Massachusetts, where I am, paid FMLA took about 20 years to pass. And this is not unusual for a workers' rights bill or any bill for that matter. There are thousands of bills that get put forth in any session, and it is impossible for our legislators to tend to all of them. But the committee members are the ones who decide in this initial hearing, which is one of the first parts of the process, of whether it goes forward or not. Typically, there will be either a joint committee that will put the bill into either the Senate or the House, or there will be a Senate Labor Committee for the Senate and a House Labor Committee for the House. Or your state might actually be different from that, but that's been my experience. And there is a staffer that sits on that committee, and they can be key to making this bill move forward. So if they're receiving a ton of testimony, they can decide, okay, now it's time to take this to a floor vote, or a committee vote rather. That actually happened in Massachusetts here with a previous bill where that staffer was receiving a ton of testimony in support of that piece of legislation. They said almost as much as gun control, and they moved it to a vote in that committee because of that. So this piece is vitally important to the process. So what is testifying? It's telling your story or your angle. It could be more fact-based, statistics-based, to legislators who have the ability to enact law. It's really that simple. We testify to create urgency around this issue of workplace bullying and mobbing, to create public awareness about the problem of employee exploitation, to educate our state legislators and to get them to either not oppose the bill or actively support it, reminding ourselves that they work for us, recommend a solution, which is the Workplace Psychological Safety Act, knowing throughout all of this that legislators have the power to enact change and make this a law. And they also want to get reelected, which is key to this process. So you speaking up, especially in numbers, shows that you can organize and potentially unseat them. So they have a vested interest in listening to you and potentially acting on it if they're in support of what you support, if they want to get reelected. So I'm going to walk you through this continuum here and start you on the left, but we always want to try to move people to the right here. So if somebody opposes this bill, and this we want to get bipartisan support, but this typically happens with conservatives, or conservatives are more likely to oppose the bill because there will be a cost associated with it. We want to neutralize them or convince them through convincing them that there are already a ton of costs to the state and also businesses that are already happening by not doing something. And of course, they want to minimize regulations on businesses, but in not regulating this issue, it's actually costing us more. So we want to actually move people from opposing it to this middle area of remaining neutral. We at least want them to not publicly oppose this. So People who are already neutral or tend to be neutral on this are the moderate Democrats. Of course, it depends what state you're in, but I guess I'm saying that from my being in Massachusetts. But we want to get their support by showing them the facts on this issue and sharing our stories. Of course, if somebody already, we want to move them to supporting this issue. Of course, if somebody already supports this issue, we want them to take more public action or any public action. So we want them to champion this bill. We want them to talk with their colleagues about it, to record a video for social media, to write a letter of support to the committee heads who held the hearing, to write an op-ed to the paper, anything that will express public support and build awareness of this. So lobbying and testifying are at the heart and soul of passing legislation, and one will not suffice. We are asking everyone to do both. We want you to tell your story over and over again until something is done about it, knowing that this is a marathon, it is not a sprint. It will likely take years to pass this bill. So who are your state legislators? They are elected officials who represent you. They are human beings, just like us. They are not experts, and you don't need to be either. With thousands of bills being presented in their state legislatures, and they only have time to tend to certain issues. But some of those issues are what their constituents care about. So they care about getting reelected, but they can't possibly know every angle of every issue. So you don't have to know every angle either. They just want to hear your side and your lens of how you perceive this issue. They want to hear from you. That's their job, to listen to you. So they will act when we make enough noise to pressure them to act. So here's how this works. So we want to write out our story or our points. So we write it out first so we stay on track, and we can also use it when we lobby, but we want to keep this brief. We want to keep this under 3 minutes. Actually, in Massachusetts, we are timed. There is a timer counting down so that we stay under 3 minutes. We get cut off at that 3-minute point. So you want to say everything that you want to say in those 3 minutes. It might be different in other states. I know I testified in Rhode Island, and they're a little bit more lenient. I mean, we try to keep it under 5 there, but if you already have it prepared for 3, you're good to use it in Rhode Island too, and probably any other state. So I would start to outline things like what industry you worked in, what did you do, and you don't have to name. You can decide. I would not name my abuser, but I would think about whether how you feel about naming the company. That could be okay. It just depends on what your comfort level is. You could talk about how the bullying began, what tactics were used, how it escalated, maybe 1 or 2 key extreme examples you could give, how you felt, how your employer reacted, or in a lot of cases did not react, what the impact was on you, any visible impact on the organization, if you see one, and why you want this legislation to pass. And you can bolster it with evidence, statistics, relevant articles. You can actually give them your written testimony after you've read it, if you choose to read it, or you can submit it only as in its written form, and you can submit other materials with it. And we also have pre-written testimony topics on different angles of this, whether that's how it overlaps with discrimination, how it ties in with OSHA, or how we can learn from OSHA to develop standards around psychological safety, how US laws are around this, how international laws are around this. So just different angles of the topic. Like I said before, watch your inbox for action alerts once you've signed up on endworkplaceabuse.com about when and how to sign up to testify, and you can encourage others to do the same. This is all about power in numbers. So coworkers, former coworkers, family, friends, anyone who you feel safe with supporting you. So you want to make sure that that is a criteria for asking other people to help. And then comes testifying. So you want to make yourself available by the phone for a few hours that day, assuming it's a virtual hearing. You may decide to take the day off if you're unable to work from home or state employees. Some states do not allow for political activity during working hours. So you want to make sure if you're a state employee that you take the day off. So what's going to happen? We have experience only in Massachusetts or Rhode Island. In Rhode Island, you testify by phone. So you want to watch for a phone call coming in from that during that time from a Rhode Island number. You want to make sure you answer it from that unknown Rhode Island number. You will not have a way to call back. You'll wait a minute after you pick up the phone, and then you'll read your testimony when prompted. In Massachusetts, it was an online hearing. You may wait hours until the bill is called, more time for your actual name to be called. You can simply read your testimony when that happens. It's a little different for in-person hearings. The same thing would happen. You would have done both in Rhode Island and Massachusetts, and you would just simply show up, put in your name, wait for the bill to be called, and then your name within that, and you can simply get up there and read right from your paper. The more engaging you can be in looking at the committee members, the better, but you don't have to. It can be nerve-wracking, especially the first time. So even if your voice is shaking, like, you are there speaking out for your own health, your own mental well-being, and that's huge. So it will be different as we expand from state to state, but in a nutshell, that's the way things have been working. And then you want to follow up. You want to keep the pressure on. You want to email the committee members using the form from the state, from your state or whatever state you testified in, using the map on workplacepsychologicalsafetyact.org or endworkplaceabuse.com. If a committee member or your own state legislator shows public support for it, you can reward that by sharing their post and amplifying it, and then getting other people in your district to call or email in support of the bill and let them know what the bill numbers are. And keep telling your story. And then you want to keep telling your story. You want to tell your own state legislators or legislators in other states with active workplace psychological safety acts. Once your email is already written or your story's already written, you can just copy, paste, and send it to every legislator in your state if you want to, especially when you receive action alerts from our group. And if you've already given your public testimony, your story is already written. If you want to email all legislators, you can do it in 2 hours. You can send 10 a day. It's just a matter of keeping the pressure on and getting it to the top of mind of legislators. So, like I've mentioned, in Massachusetts, there are over 6,000 bills filed each year. So many issues are as compelling as ours is. So whoever makes the most noise gets the attention. So this doesn't stop until we win. It's about winning over our legislators individually and about winning over powerful committees and their members when you receive action alerts. Here's an example of a hearing. I'm not actually going to play it because it is hours long, and it begins about 3.5 hours into it. It is emotionally draining. You could watch it in segments. There's the URL. But if you want to see how it works live, and then here is a pared down version of how this worked with the previous bill that we've worked on for the Dignity. This was for the Dignity at Work Act. This was just pulling out some of the points.
Thank you for this opportunity to testify in support of the Dignity at Work Act. What our laws do today is not enough. We must pass a strong law with strong enforcement that will protect targets and motivate employers to take the necessary steps to prevent, detect, remedy, and eliminate workplace bullying.
But discrimination law is not enough to help us, even though there's a discriminatory impact with this epidemic.
The only course of action given is for them is to give up and exit the organization.
Left unattended, bully stories will come to control workplace climate and the direction of operations in wrapping everyone.
Or when I talk with a mother of an adult child who took his or her life because of relentless workplace abuse.
Had a supervisor used to call me into her office and would spend the first 30 to 45 minutes of my workday screaming at me.
4 decades of research reveal my demise was set in stone the moment I reported abusive behavior.
I wonder how you would feel if you watched your loved one go from being a vibrant, happy person who loved their job reduced to a puddle.
They have non-disclosure agreements. They basically are really good at silencing victims.
Systemic racism, sexism, and classism pervade our school systems.
Microsoft's attempt to steal my voice with an NDA that caused the most harm to me. Policies and training videos are worthless unless they follow through.
I began to understand why people contemplate suicide when they're bullied.
Severance, a non-disparagement agreement, and an offer of tens of thousands of dollars to leave quietly.
If DAWA had been in place when I was going through this ordeal, perhaps the bully would have thought twice.
There is a culture of bullying that is passed down because there is no legal remedy.
There are still employees being abused by this company and afraid to come forward.
I'm testifying in honor of my sister, Leslie Ellington's memory, who was also a victim of bullying.
Inability to use my education and expertise
Is a criminal offense prosecutable and compensation worthy for everyone else but a fellow employee.
I've experienced working for Broadway and film producer Scott Rudin, discriminated against women and people of color, firing them far more frequently than white men.
Its function was to maintain the status quo of a culture where racism and discrimination were channeled through bullying acts.
The tactics that were used were atrocious.
Economic instability, job insecurity, absentee leadership, rigid hierarchies.
The person responsible for most of the workplace abuse was allowed to act as the decision maker in my mere survival.
Dozens of lawyers tell me there's no law against being a jerk.
And it needs to stop. We need your help.
We need to do something about workplace bullying.
So if you have questions, that was for a different piece of legislation that we've worked on. But if you have questions, feel free to email us, or if you want to get involved, we are at info@endworkplaceabuse.com. We're looking forward to working with you.